A judge in the Reese versus ATF case, a lawsuit brought by the Second Amendment Foundation and the Firearms Policy Coalition, has ordered those organizations to turn over their members list to effectively enforce a judgment. This comes at the request of the Department of Justice, who convinced the judge to issue this order. This amounts to none other than a registry of gun owners for the Department of Justice, something that the federal government has been attempting to create for a long time. Today, we're going to talk about Reese versus ATF and the consequences of this decision for gun owners. Hi, I'm Ben, and you're watching the Minuteman Moment. So, Reese versus ATF. What is it and how did we get here? For starters, the lawsuit itself, filed by Second Amendment Foundation and the Firearms Policy Coalition, is challenging the federal ban on the sale of handguns and handgun ammunition by federal firearm licensees to adults who are under 21 years of age. Under current federal law, it is illegal for any licensed gun dealer to sell a handgun or handgun ammunition to any adult between the ages of 18 and 20. Although those individuals can purchase rifles, shotguns, and other firearms. You can thank the 1968 Gun Control Act for this ridiculous infringement. Specifically, Section 922b1 says, "It shall be unlawful for any licensed importer, licensed manufacturer, licensed dealer, or licensed collector to sell or deliver any firearm or ammunition to any individual who the licensee knows or has reasonable cause to believe is less than 18 years of age, and if the firearm or ammunition is other than a shotgun or rifle or ammunition for a shotgun or rifle, to any individual who the licensee knows or has reasonable cause to believe is less than 21 years of age." This is just another example of the Second Amendment and the right to bear arms being treated as a second-class right. So, in November of 2020, FPC and SAF sued the ATF over this blatant infringement. On a side note, GOA also sued on this same issue, just in a different jurisdiction. If you'd like to see videos about that lawsuit, let us know in the comments below. SAF's lawsuit, Reese versus ATF, was filed in the United States District Court for the Western District of Louisiana. They were assigned a Trump-appointed judge, Judge Robert R. Summerhays. SAF and FPC's arguments plainly state that the handgun ban is unconstitutional, arguing that the right to keep and bear arms extends to 18-year-old adults looking to defend themselves with handguns. They cite Heller, quoting the Supreme Court, who recognized handguns as the quintessential self-defense weapon. They go on to state correctly that there's never been any constitutionally grounded basis for restricting the rights of law-abiding adults over 18 yet under 21 years of age who are eligible to serve in the military and die for their country. Well, on January 30th, 2025, the Fifth Circuit Court of Appeals agreed, striking down the law for violating the Second Amendment. In their ruling, the judges wrote, "Ultimately, the text of the Second Amendment includes 18 to 20-year-old individuals among the people whose right to keep and bear arms is protected." Another quick side note. Later in the year, on June 20th, 2025, a different appeals court ruled the opposite. The Fourth Circuit Court of Appeals ruled in the case Fraser v. ATF that the ban of handguns for 18 to 20-year-olds was completely in line with the Constitution. This is what's known as a circuit split, when two appeal courts issue rulings that contradict each other. Because of this split, it's now more likely that this issue will eventually find its way to the Supreme Court to resolve this contradiction. So that brings us to present day. Judge Robert R. Summerhays has entered into a judgment at the behest of the Department of Justice that stops the enforcement of this unconstitutional infringement. But here's the catch. In the judgment, it reads, within 21 days of this judgment, those plaintiffs identified in paragraph 2b, that's FPC and SAF, shall provide to defendants a verified list of their members as of November 6, 2020. Translation? The federal government just ordered the Second Amendment Foundation and Firearms Policy Coalition to turn over a verified list of their membership to the ATF. Their reasoning? Well, according to a filing from DOJ, they said, in sum, defendants' proposed judgment appropriately limits its scope to members of the organizational plaintiffs who have been identified and verified to defendants during this litigation. Any injunction that does not include this limitation would be impermissibly vague. Sounds like the ATF has learned from the previous times that we at GOA enjoined their rulemaking efforts, once for each Biden executive order. The pistol brace rule and the engaged in business rule were all enjoined by us. As a result, Gun Owners of America members currently enjoy protections against those infringements. But we didn't have to give up a verified list of our members to do so, and neither should FPC and SAF. Of course, the government's motivations for wanting this information are sinister. There's nothing that the ATF would want more than another backdoor registry of gun owners, this time through a list of members that support gun rights organizations like SAF and FPC. Not even the Biden DOJ ever attempted something this inexcusable. The Department of Justice must immediately rescind this demand. But here's where you come in. Call the White House at 202-456-1414 and demand that President Trump order the Department of Justice to work with GOA, SAF, and FPC to protect gun rights and to restore the Second Amendment. We'll keep you updated as this case develops. For the fastest updates, follow us on X at Gun Owners. Now thanks for watching. Be sure to like, comment, and subscribe to stay up to date with GOA's latest fights for your rights.